Have you ever wondered how criminal defense attorneys get felony cases dismissed? Watch this video to learn the process. We've developed a tried and true process to helping clients seek dismissals in every case. The first step is to gather all the evidence, not only from law enforcement, but from our independent investigator. Once we obtain all the evidence, we review it to see what the cops did or didn't do that was right. Did they go into someone's home improperly? Did they enter that vehicle without authority? Is there something the cops did that they could not do? We try and identify these issues to help our clients seek what's called suppression of evidence. Suppression of evidence is basically legalese for keep stuff out of court. If the government can't use crucial evidence in their case because it's suppressed through the process, that means the government cannot proceed and your case could be dismissed. Recently I had a client who was charged with aggravated drug trafficking and drug conspiracy in federal court. He was facing up to a decade plus in federal prison. However, once we obtained the evidence from the government, we realized that the officer violated our client's rights. The traffic stop was improper, how long they kept our clients at the scene was improper, and that drug dog didn't exactly sniff something that led to a search of that vehicle. We filed a suppression motion in the case, had an evidentiary hearing, and the officer admitted on the witness stand that he pulled our clients over because they were black. Ladies and gentlemen, it is not a valid basis to stop someone based on their race, gender, or anything else that is about that individual. It must be based on evidence of an actual crime having been committed. And the judge granted our motion to suppress, and the U.S. Attorney's Office was forced to dismiss the case as they didn't have any evidence. This is a crucial process that our defense firm, along with all experienced defense attorneys across the country, use to ensure that your rights were not violated by law enforcement. This is a foundational issue in every case, because if law enforcement violated your rights, it is more important that you go free despite having committed a crime than law enforcement be allowed to violate people's rights. When we submit a suppression motion and have a hearing, we don't know what the cops will say. They could testify something completely new, there could be a wrinkle that nobody expected, and potentially there could be new crimes that they allege against our clients. That uncertainty leads to many cases being resolved at the point that suppression is being discussed. Prosecutors don't want to take a case in front of the judge at a suppression hearing and lose the day and potentially lose credibility with the court. Additionally, prosecutors and defense attorneys both don't like going to trial and losing. Obviously, if I take a case to trial as a defense attorney and my client loses, they lose their freedom. Alternatively, if a prosecutor takes a case to trial and they lose, that negatively impacts their reputation, how their prosecution office is seen, and can have ripple effects across their office and other cases that they are attempting to prosecute. That's why when defense attorneys are able to identify issues in the case, violations of clients' rights, or when the cops didn't do things the way they're supposed to, prosecutors very often will dismiss charges or resolve cases with less serious consequences for our clients to avoid the risk of being wrong about a suppression issue and avoid the risk of losing at jury trial. So separate from all the legal issues related to police misconduct or suppression, there's also the human side of the case. Oftentimes when prosecutors get a case, all they see about our client is a name and their prior record, if any. It is our job as the defense bar to make sure that we tell the story of our client and build them up as more than a case number and what their past may look like. Our team at Cannon Associates work with clients and their families to find a path forward, not just a resolution of their case, but also set them on the right path for their life outside and beyond their case. When we're able to put this information together and present it to the prosecutor as a plan to successfully get our client out of the system, oftentimes it allows us to seek resolution in agreement of the government for a much less serious consequence for our client. I hope you enjoyed this video and it answers some of your questions about the justice system. Click the subscribe button and watch some of our deep dives for more answers to your common questions.